Good morning, everyone, and welcome to our monthly webinar. My name is Rihanna Badenhorst, and I'm the Pro Bono Coordinator and responsible for consumer education at the Financial Planning Institute of Southern Africa. Today, we are talking about marital regimes and how it affects our finances. Our speakers today is Sheila-Ann and Katlgeo. Sheila-Ann is a certified financial planner and an attorney. She holds an LLB degree, an LLM insurance law, and postgraduate diploma in financial planning. She's relentlessly aspiring to acquire experience and knowledge to secure success for herself and her clients. Katlgeo is a certified financial planner professional and holds a BCom degree from the University of the Witwatersrand and a postgrad diploma from the University of the Free State. With a strong focus on personal finance, Katlgeo specializes in helping clients achieve their goals through comprehensive planning and investments. We are fortunate to have you guys on this webinar this morning, and with that, I'll hand over to Sheila-Ann. Thank you so much.
Thank you very much, Rihanna. And I think I speak for Katlgeo and myself when I say we are very happy to be assisting with the consumer education, in particular, the principles of marital regimes and how they affect our finances, which is what we'll be chatting about today. And Rihanna, can I just confirm that the slideshow is visible to the audience?
Yes, it is.
All right, super. We'll kick off just going through the slides and casually chatting between Katlgeo and myself, trying to impart as much knowledge as we possibly can to the viewers, whether they be in financial advising, whether they be consumers, whether they be students. So just a little tongue-in-cheek, love is more important than money, but have you ever paid bills with a hug? And this is just to break the ice a little bit. As we know, in our society, from a cultural point of view, and as South Africans, it's quite taboo to talk about money, especially in the throes of love and relationships. And before a wedding, I think the last thing that clients chat about is what marital regime to undertake. Katlgeo, I don't know if it's the same for you in your experience with your clients. You know, us as advisors are always prepping them about financing the wedding, but they hardly ever ask about antenuptial contracts or marital regimes and what the impact thereof will be on their money.
Yeah, I find the same with my clients, Sheila, and I think it also stems from some sort of a fear of talking finances before the marriage. At that stage, a lot of people just focusing on love and romances and the good things about the relationship, and still finding it a little bit awkward to talk about money. But I want to encourage everyone out there that this is an important topic, an important thing to discuss and cover before you actually get married. As we go through the different regimes and what they mean, hopefully that helps you understand and get a little bit of a better idea, so that you're more comfortable to have those conversations.
And I think if you look at the next slide, the answer is financial literacy. And I think that's our role as financial planners, is to run around South Africa just educating our clients, and with us as volunteers and the FBI doing the most to try and impart this knowledge that is readily available. I think it's just overwhelming for South Africans in general, because there's so much information. As Katlgeo and I know, just preparing to obtain our CFPs and doing a postgraduate in financial planning, there is so much that goes into what affects people's finances. It's the tax, it's the law, it's the emotional and behavioral aspects surrounding money. And financial literacy really is the answer to prepare our clients before they enter into nuptials. In South Africa, the marital regime you choose determines how your assets, income, and debts are managed during the marriage, but also in the event of separation, divorce, or death. And I think that's what a lot of South Africans forget, is that once they enter into a marital regime, that tabooness is about, on the precipice that they are not going to separate. However, the consequences of a marital regime are also, brought about in the instance of death. And I think that's where a lot of South Africans fall short, because they don't take that into consideration. I think I've seen a lot of widows suffer, on the death of a spouse, where they are subject to the consequences of having a joint estate wound up. Katlgeo, I don't know if your experience is similar.
Yeah, I agree with you there, Sheila. And I think that stems back to fear, in my experience, and being uncomfortable with getting uncomfortable. And I think the first thing about a marriage is, be comfortable with having uncomfortable conversations. And just to say, like, talking through things like this does not necessarily mean you're planning for the worst to happen. It just means you and your future spouse are talking about it to understand, if things happen, what's the likely outcome going to be. And as you correctly put it, it's not only the bad as we see it as, no, I don't want to plan for a divorce, but it's also death. So what happens on death of a spouse? What does that look like? What does it mean for the surviving spouse? So yeah, I think definitely worth it. And a point I want to add, I think, Sheila-Ann, is definitely, as you correctly put it, there's a lot of information out there. The best way to, get help and decipher everything that's out there so that you understand consequences is definitely to speak to a certified financial planner, so that, you can talk through the different options, what it means, and then make a decision on what you want to do before you enter into marriage.
Yes, I agree. And just to touch on the fear aspect, I think not necessarily just fear, but pain. There's a lot of pain involved in a dissolution of a marriage, whether it be from separation, divorce, or death. And human beings naturally tend to avoid their pain. The advisory part of what we do is such a critical aspect. And like we've said here in the slide, there are 3 primary marital regimes in South Africa, but there are 2 sub-regimes which you and I will discuss going forward, and what the implications are. And I think also it might be important to advise clients step by step, like from the beginning, like you've gotten engaged, you are busy planning a wedding, what's next? How do they engage with qualified professionals? Where do they reach out to? I think it's not necessarily about not having access to knowledge, but where to start, where to go. So just as a fun fact, among the over 100,000 civil marriages registered at the Department of Home Affairs in 2022, just over 20,000 divorces were granted. So it's an interesting statistic. About 18% of people that were married in 2022 got divorced. So it's not that our society is not dealing with the implications of a marital regime. Later in the slides, we'll take a little bit of a deep dive into the statistics behind those divorces, what demographics are they affecting, so that we can uncover what the financial implications will be. So just in terms of the 3 main marital regimes, we've got in community of property, which is our default regime in South Africa, where the estate is considered a joint estate and assets are divided 50-50 on dissolution, whether that is through divorce or death. Out of community of property with accrual, where the one who accrues less gets half of the difference. Katlgeo will walk us through an accrual calculation in a moment or two, because I think that's also what scares a lot of South Africans, is that they don't understand the implications. So they'll rather just avoid considering getting married out of community of property with the accrual system. And I think after today, with our high level / basic level explanation, it'll be something a little bit easier to understand. And then lastly, out of community of property without the accrual system, where both estates are completely separate, whether that's on death or divorce. So as you can see just from the top tier marital regimes, out of community of property without accrual is the one that will have the least impact financially on two separate estates. Yeah, and then I'll hand over to my very learned colleague Katlgeo to walk us through what shows us flames in the CFP fraternity is the dreaded accrual calculation.
Yes, Sheila-Ann. And I think just to maybe take a step back to looking at all three of them, I think we always need to remember that, you know, between the two spouses, you guys need to look at your different circumstances, whatever that may look like. If it's a one income household, maybe the one spouse is working and the other one is responsible for taking care of the family, whatever it is, and just go through the different consequences of each and decide which one is going to work for your specific scenario. Just to make sure that, you know, it's also fair at the end of the day. And that's my philosophy, you know, try to make things fair so that at the end and the solution, if it does end up in divorce, you know, you're not you're walking away with nothing.
Yeah, but just, no, we don't want a whole bunch of South Africans who haven't accumulated skills because they've been home executives walking out with just a black plastic bag and not being able to contribute to society. And that's why there is the three different regimes.
Yeah, so I'll just jump into the accrual calculation just to give our audience an idea. For interest, this is the way I'm married. So I'm married with an antenuptial contract with accrual, and basically what that looks like is they'll at dissolution of the marriage, whether it's death or divorce, we look at the net asset value at the end less the net asset value at the beginning, adjusted for inflation. In this very simple example, I've got Jack and Jill, who got married in 2010 and then divorced, unfortunately, in 2022. So Jack's estate at commencement, meaning a beginning value, and that was adjusted for inflation, and I put that as 1.5. Jill at 2 million, and then Jack at the end of the marriage, his estate has grown to 4 million. Jill's estate has grown to 6. So basically we look at Jack first, we say 4 million less 1.5, that's 2.5 million net. And then Jill is 6 million at the end, less 2 million from the start value, that's 4 million. So from the two, we can see that Jill has got the bigger estate. So we subtract Jill's estate of 4 million and from Jack, so Jack's from Jill, sorry. So 4 less the 2.5 will give you 1.5 million. And that is then divided by 2, which means that Jack will be entitled to the difference, which is 750,000 from Jill. So now that means Jill needs to raise the money to pay Jack. And it's something that, you know, if you don't plan for it or you don't understand it, it can catch you off guard.
And just in these instances, in my experience, just, you know, for the viewers, because an antenuptial contract is a contract, it's something that you can contract into and contract out of. So if you have a spouse, in the instance of divorce, if you have a spouse that is willing to negotiate some sort of settlement of the 750, that is available to you. Obviously to consult with an attorney in this regard, so that your divorce settlement agreement makes provision for that. obviously we understand that usually in the face of divorce, you don't have a very negotiable spouse. And in this instance, oftentimes the spouse that is required to settle an accrual payment will have to dispose of assets to cover this cost. This example, as Katlego put forward for us, is obviously in the instance of divorce. However, the same sort of implications and consequences come about on death of a spouse. So oftentimes we will have clients who either die without a will in place, or they have a will in place where they leave the entirety of the residue of their estate to their spouse. However, that your estate on death also has to settle any accrual payments that are due, which is over and above, leaving your entire estate. The executor of your estate can do a set-off in terms of where, if you're taking a certain asset in lieu of an accrual payment as cash. So there are options available, and the best way, and I think Katlego will agree with me, in the instance of death, is to make provision for a life policy to settle any claims against the estate, like accrual claims specifically.
Yeah, in my experience, Sheila-Ann, and this is why also always have these discussions with your spouse before marriage, during marriage, all the time. Make sure you're on the same page. Make sure you know what's in your spouse's will. So, because that's a critical document when we talk about death, because where your spouse leaves everything to you, or you leave everything to your spouse, that scenario is ideal, because everything is going to be left to the surviving spouse in any event. But where the spouse has left their estate to other people, that means you as the surviving spouse may need to now fight with those people, or set your claims against the estate, because now that's when the accrual claim needs to really be settled, because not everything is coming to you anymore. There's other people that also needs to get sorted out. So know what's in your spouse's will, understand the implications, chat to a certified financial planning professional to help you understand the consequences. And there are solutions, as you correctly put it, Sheila-Ann. Sometimes just a life policy can solve a lot of headaches for many people. But I think the critical point is understanding what those mean when drafting a will, and make sure that that will is drafted and that it's reviewed from time to time.
Yeah, absolutely agree. And just as we discussed before, in terms of the nitty-gritties about going about learning about this, we've said reach out to a certified financial planner. Our details are all on the FPI website. We're a Google click away just in terms of that. So once you've got engaged and you're planning a wedding, have that consultation, find out the implications of all three, as we'll be discussing today. And then it's to decide which marital regime suits you best. I think clients forget so the in community of property is our default regime. So that requires that you do nothing. You can get married on the day that you get married. You can get married at home affairs, and then out of community of property is applied as your marital regime by default. If that is something that you want to deviate from, whether you've had the consultation or not had a consultation with a professional, and a lot of advice with a CFP is at a low cost or free of charge. The resources are available. To put an antenuptial contract in place, which includes this accrual system or doesn't include the accrual system, requires that an attorney draft an antenuptial contract, and this has to be before the date of marriage. So before your marriage is registered at Home Affairs, your antenuptial contract has to be drafted by an attorney and notarized by a notary republic. That is then registered together with your marriage, and then your marriage is subject to out of community of property and deviates from the default system. Just to give our audience a little background in where and what and how, but it
Yeah.
has to be before marriage is registered. And if I'm not mistaken, within 3 months from registration of marriage, that it must be registered. Okay.
Yeah,
And
so
then,
important that drafting, and I'll get into customary marriages just now. But yeah, sorry, Sheila, and I rudely interrupted you there when you wanted to say something
all
else.
good. All good. And just, following on your accrual system, just if you can highlight for us, Katlgeo, what's excluded from that accrual calculation, so that our viewers have more insight.
Yeah, so definitely, and this is something to remember when drafting that ANC or antenuptial contract, that you can exclude certain assets. So, for example, where it's a couple that has accumulated assets before marriage, they can then in the antenuptial contract exclude certain assets, and those won't be taken into account in the accrual calculation. Other things that are excluded is inheritance, donations, as well as damages for personal injury and life insurance benefits. I think the next slide speaks nicely to my point earlier about customary marriages. Now, as Sheila-Ann already told us, that the default is if you don't draft an antenuptial contract, you are then married in community of property, meaning it's a joint estate. You own things 50-50. So I've seen a lot of this where people are getting the customary negotiations, lobola negotiations, and then there's a celebration that happens. And the stats show that not a lot of customary marriages are registered. So you are encouraged for your protection to get your customary marriage registered with Home Affairs. Just to remember, a customary marriage, it doesn't mean if you want to get married A and C, you mustn't follow a customary, your traditions. I mean, we live in South Africa. We have diverse cultures and traditions that should be followed. But just be careful on the process you follow. So in order for a customary marriage to be recognized, I think that's the next slide. So both prospective spouses need to be 18 years and older, give consent, and the marriage must be negotiated, entered into, and celebrated in accordance with customary law. Now, I see this a lot. So we have, on the one day, the uncles are sent, there's a negotiation, something is agreed, there's the bridal price or the lobola, that's paid. A lot of couples these days do complete the entire process in a weekend. So the one date will be at the bride's home, and then the following day the bride is delivered to the husband's home and it's celebrated. Just to be very careful, that now means you've concluded a customary marriage in community of property. If you want it to be out of community, meaning apply an ANC with or without accrual, you need to make sure that before this process is concluded, so before there's a celebration, you do need to draft that ANC and put it in place and make sure that it is the thing that you want. Otherwise, it falls into the default of in community of property, because customary marriages are in community of property. Just an additional fact. So what about polygamy? So important to remember that customary law allows for polygamous marriages, but only if all marriages are customary. So just to explain that, one person cannot enter into a civil marriage. So for example, I'm married to my wife. It's a civil marriage. There's an ANC in place. I cannot now go and say, well, I'd like another wife, and that can be recognized in terms of customary law. The law doesn't allow for that. So you can't have a civil marriage and a customary marriage. The civil law doesn't allow for polygamous marriages. If you the type of person that wants to enter into polygamous marriages, very important, you then only going to do customary marriages. It shouldn't be a civil marriage.
And then, Katlgeo, I saw, I mean, you and I have discussed previously about what are the implications of lobola from on dissolution of a customary marriage. So, for our viewers, what happens to someone's lobola if you get divorced?
Yeah, that's an interesting one, Sheila-Ann, and I think a pretty contentious issue. So the law is not very clear on what happens, but there is case law that can be looked at. In certain instances, the lobola can be claimed back, and in other instances not. And I think this is also as a result of different traditions and customs that are followed throughout the country. So there's not a clear-cut answer, but yeah, my feel for it is once you've paid it, make peace with the fact that it's paid. Don't try now and go get it back at a later stage. Unfortunately, in life, you win some, you lose some. So that's my philosophy, but I understand that sometimes people would want to claim what they have paid, and rightfully so. But yeah, long and the short is there's no clear-cut answer. It just depends on the different customs that are followed.
Yeah, and it's so funny, in traditional Western culture, the engagement ring is comparable to lobola in a customary marriage negotiation, and there is clear-cut law that engagement rings now fall part of the wife's estate on dissolution of the marriage. So it's not able to be claimed from the husband can't claim the engagement ring back, whether it's on divorce or death. So just an interesting comparison. Just moving on to the next slide.
I think hence my comment about once you bought the engagement ring or paid the lobola, just accept that, something you did at that time, hopefully from the bottom of your heart. And so be it.
And I think that speaks to the next slide, is that I think our clients and consumers in general, and that's the nature of human beings, the relationship with money and the relationship with marital regimes or anything legal or financial is sort of put on the back burner. Financial implications are put on the back burner because we are human beings and we're driven by emotions. And it's our job as certified financial planners to ensure that our clients are still making informed decisions, regardless of the heightened emotional state, whether that be at inception of marriage, whether that be at dissolution of marriage or at death. And I think we are required to wear many caps throughout the life cycle in our relationship with clients. Some of the financial implications that are affected by these marital regimes is purchase power. In certain instances, the default marital regime of in-community of property hinders a spouse's ability to contract, to enter into business negotiations, as you'll see in business trading. So a lot of contractual transactions require the consent of the in-community of property spouse. So your ability to transact is limited based on your marital regime. The financial implications on divorce, obviously, Katlgeo has given us explanation of an accrual claim calculation, but we haven't nearly touched on child maintenance claims or spousal maintenance claims, which I've touched on at the end here, and then on death. And I think as part of the default marital regimes, I think clients forget, in my experience, when a joint estate is being wound up, practically speaking, it takes about 6 to 8 weeks for a letter of executorship to be issued by the master's office. In those 6 weeks, the surviving spouse still needs access to money to pay water and lights and normal bills and groceries, etc. But without a letter of executorship, it's very difficult to transact as the joint estate, because you, as the surviving spouse, are part of the joint estate that's busy being wound up. You are in the midst of an administrative process. And I think, Katlgeo, I'm not sure if you'll agree with me in this instance. Again, a life policy is a solution that makes available cash to the surviving spouse where you are married in community of property.
Yeah, I think to my mind now, the example that jumps out is back to my example where if there is one breadwinner in the home and the breadwinner passes away, that always, I know that's, yeah, to me that's always the extreme example I think about, and try to use that to get people to understand that in that scenario, if you don't have money of your own, save somewhere that you can use in the meantime to fund yourself, you are sitting in a problem. Hence, yeah, you'd need different to make sure that there's things in place to take care of you. A life policy being a very good solution, but again, chat to your spouse, understand the implications. Always consult a certified financial planner to make sure you are, I like the words you use there, Sheila-Ann, making an informed decision. So, and I think that's so key. People often don't want to speak to financial planners and a financial advisor because they just want to tell you what to do or whatever. It's not about that. It's about helping you, giving you as much information as possible, talking through the different scenarios of what's going to happen, what's possible, what's not possible, so that you understand and can make an informed decision, so that you're not taken by surprise when something does happen.
And I agree with you. And us as financial planners as well, we are also human beings and we have internal biases. Like, as a result of my legal background and still being in practice, I naturally favor being married out of community of property without the accrual system. And just from an administrative point of view and what I've experienced in practice and what I've experienced in my own life, also having been married out of community of property with the accrual system, and also holding my clients' hands when they are subject to the winding up of a joint estate. So also, you know, the more I support clients and advise clients and prepare anti-nuptial contracts and have the consultations, I become more aware of my own internal biases. And I think that's what makes us better financial planners, is not just having, you know, the knowledge, but also the soft skills to support clients so that we don't project our own experiences onto them, but guide them to a solution that serves them the most.
100%.
Just as one of the stats from the fun facts, where about 18% of registered civil marriages in 2022 ended up in divorce. I wanted to just touch on the slide of those 22,000 divorces that occurred in 2022. About half of those, more than half, had children below the age of 18, which means that they were naturally financial dependents of those households. And I think that's what clients fail to take into account as well in terms of their financial planning journey, that divorce in itself is one of the most devastating financial occurrences that could happen in a client's life. Not just from an emotional point of view, but obviously from a financial point of view. Katlgeo went through the implications of the accrual claim, but also spousal maintenance and child maintenance is something that clients really need to be aware of. And just in terms of the stats, what percentage and portion if we look at the Black, African, and colored divorces involving couples with children constituted but just under 60% of the 20,000. So it's not it's everyday people that are getting divorced. It's not your upper class, it's not your middle class, it's not your lower class. Everybody is affected, by divorces, and especially where minor children are involved. Katlgeo, I don't know what your practice can yield from an experience point of view, how you've assisted clients from a financial planning point of view in the event of divorce where minor children have been involved.
Yeah, I think there's one thing that comes to mind here, Sheila-Ann, and it's failing to plan is planning to fail. So
absolutely,
if you don't plan for it, you're guaranteeing an outcome that things will fall apart. And I understand, people don't like talking about these things. Like, who walks in and wants to talk about what happens if I get divorced? What happens if I die? Like, I understand it's bleak discussions. And I also want to encourage fellow financial planning professionals not to shy away from these discussions, because it's a reality, as the stats are correctly showing us here, that people, it's everyone. This can happen to anyone. So always plan for different outcomes. Yeah, in my experience, I've seen a couple of divorces. I've seen how it affects children, especially, because then all of a sudden the children's lives also stand still, because as you mentioned earlier, it's hardly ever amicable. It becomes very difficult for the two parties to sit at the table and discuss, okay, this is how we're going to handle things, and everybody finds a working solution. It's often very tit for tat. It's a bitter situation. Children need to get dragged to court. Children need to take the parents to court for maintenance claims. It's not ideal, but it's important to talk about this and plan for it. And also just apply your mind as an individual. Should a situation like that arise, what would you like to happen for your children? And make sure you make the necessary provisions for that to happen, or try to plan as far as possible.
And then, today we're not even touching, we haven't even discussed, the implications of divorce on a pension fund. And we'll leave that to the retirement specialists in a different webinar. But the costs of financial ignorance. So obviously, being uninformed at the date of inception of your marriage, defaulting into an in-community of property situation, or entering into an anti-nuptial contract without having the necessary advice or information, because you're blindly following a spouse and the spouse's advisor or the spouse's attorney, could lead to serious consequences, either on divorce or death. One of the costs is delays in winding up the joint estate. I spoke about not having access to cash. So all three marital regimes will be affected, especially, as Katlgeo mentioned, where a breadwinner passes away. The risk is always that you'll be spending more on professional fees later. I think a large portion of our clients, with the economic state as it is today, South Africans are tightening their belts. That's just increased as well. To fork out 1,000 to 2,000, 3,000, 4,000 Rand to seek professional advice prior to going into a marriage, to get the right advice, seems like a very hefty cost. However, at a divorce or a death, having to appoint additional experts and additional attorneys or financial planners when you're either winding up an estate or getting divorced is something that can really be avoided at the outset. Katlgeo, I don't know, in your experience, in situations where some kind of a marital regime has ended up where that's been the cause of most of a client's pain, is really just, being at the mercy of what they did 10, 15, 20 years ago because they were uninformed.
Yeah, definitely. I think I see this with a lot with people, my parents' generation and the generation before. They weren't exposed to a lot of the information, so they just went with getting married, and then they, in the default, in community of property, and one of the consequences there is, your spouse's debt is your debt. All of a sudden, on dissolution of the marriage, divorce, sorry for you, we now need to settle this debt together. It's not like the spouse gets to keep their debt and go on their merry way. So that has adverse implications for you that's got no debt, for example. And I think coming to cost and professional fees, Sheila-Ann, is I think it's important to mention that you can have your marital regime changed, but you'll know better than I do that is a very costly exercise. It's not cheap to have that done.
Yeah, and rightly so. Where clients have been ill-advised or uninformed or just really lazy. I mean, I can relate to that on the best of days. I just didn't put in the work to find out. I didn't know any better at the time. Especially clients that own their own businesses, and because the ability to transact and contract is limited, and also a lot of clients wanting to protect their spouses should their businesses fail or go under, etc. Where they've gone into a default marital regime of being married in community of property and wanting to change that to an ANC later. The requirements is obviously that they need to bring an application to the High Court to change their status. So their marital regime will change to out of community of property, whether with or without accrual. And the difficulty there is for our consumers and the listeners and the viewers today is that you can bring that application to court. It will cost you in excess of about 20,000 Rand. It's still within the court's discretion to decide whether or not to grant that application. So you might proceed to spend all that money to change your marital regime, but you have to give good reasons to the court as to why you didn't implement an antenuptial contract at inception of the marriage when you bring that application, and it's within the court's discretion to grant that or not grant it. And it just increases our client's risk where it's something that could be avoided at the outset. And that's our job, Katlgeo. We really need to run around town and start advising people, because at the time you might not know better, but when you know better, you need to do better. And I think that's our role as CFPs.
Yeah, 100% agree with you. We are there to empower clients and share as much knowledge as possible to help them make these decisions. And again, let's not shy away from having uncomfortable discussions. Those are important. This was very funny when I saw it, Sheila-Ann.
Just again to closing tongue in cheek before we chat to Rihanna if there are any questions she wants us to address. But what's yours is mine, and what's mine is also mine. And just also the 6 P's is something I live my life by, but I've amended it slightly to proper financial planning prevents piss poor performance. And it's really, to encourage people to have those difficult conversations, and us as CFPs to be advocates for the layman and the consumer, so that we can rather do the painful thing now and avoid the painful thing later, I guess. Katlgeo, I don't know if there's anything you want to add in closing before we reach out to Rihanna and see if there's any questions she'd like us to address.
No, nothing from my side. I think we've covered all. 100% agree with you. Rather plan and know what you're getting yourself into, and rather than to get surprised if something does happen. Rihanna, I don't know if you have any questions for us.
Thank you, guys. This was very informative. I think I've learned a couple of things myself. I've just got maybe one or two questions, and it's more about the customary marriages. In terms of a customary marriage, if the lobola paid, but the celebration has not taken place yet, and there is a death, what is the consequences?
So lobola is paid,
but the celebration hasn't taken place yet.
So that means the marriage is not concluded.
Yes.
In my mind. So marriage is not concluded. So you technically are not married because the marriage is not concluded. If we think of it in a Western setting, you've planned the wedding, you're now there at the wedding, you've got your engagement ring, but you've walked halfway down the aisle and then something happens. So that means there's no marriage per se. Therefore, you can't claim there's a customary marriage in place.
Okay, but what is the consequences on the finances now? I mean, we're not married, but my partner has now passed away.
I can take this one, Katlego, just in terms of those requirements of a customary marriage, because the customary marriage hasn't been concluded. Obviously, it's not a joint estate as yet. It hasn't defaulted into that marital regimes, and it's two separate estates still. In terms of the lobola, as Katlego and I discussed on the case law is unclear. So whether it's for the surviving, spouse, as it were, to claim that back or not is within their prerogative, and but be that as it may, there's no implications of a marital regime that would apply, and it's just unfortunate. I would obviously, the lobola is obviously in exchange, and obviously because the exchange hasn't happened, one estate has been unduly enriched, which gives rights to the surviving spouse's estate to claim that undue enrichment back, just as a normal legal principle. I don't know if that answers your question.
Yes, it does. Yes, it does. And maybe that answers all the questions that I have in terms of the customary marriages. Maybe just the last one, and you have touched on it, but I think it's very important, where there is a marriage where there is a partner that is in a business relationship. I think it's just go through that again, because I think it's so important to realize that especially in today's age where a business can fail, how do you protect yourself from a failed business relating to your partner?
I think the difficulty there are these three beautiful words in the South African legal system: jointly and severally liable. Basically what that means is, if you're married in community of property and your partner's business fails and they've racked up debt, whether it's business related or in the individual capacity, if they've racked up debt, a creditor, whether it be for a business or for the partner's individual creditors, have the ability to claim from the joint estate jointly, because the joint estate is jointly and severally liable. So they can take your car and your house and whatever to settle what is due and owed to them as creditors of your spouse. So in order to protect yourself, as we've mentioned before, bringing application to court to change the marital regime, to ensure that you know what's going on in your spouse's business, because especially if you're married in community of property, because those business transactions, their creditors, have the ability to claim what's due and owed to them from your personal estate, because you're part of the joint estate. Katlego, I don't know if you have anything to add.
No, I just wanted to highlight the point you raised earlier, Sheila-Ann, about, spouse consent. When you're married in community of property, that means you have signed some form of consent for your spouse to be able to transact. And sorry for you, when there is a claim, you can't. I didn't know. You signed the consent for it, and you can't really get away from being held liable. So unfortunately, you are jointly and severably liable for those claims.
Just something else I'd want to add, Rihanna. One of the things that clients must be aware of is if you fail to pay school fees, regardless of which parent has taken responsibility for settling school fees, if the school is owed money, they can claim it from either parent, regardless of it being if it's a working parent, not a working parent, and you can still be sent to the credit bureau if you have school fees in arrears. So that's either parent, whether one defaults and the other parent is also liable in totality. So just to bring that to consumers' awareness as well. It's not that one spouse is responsible for school fees. Both parents of the child are responsible for school fees.
Thank you, guys. I think what's important to remember is if your spouse has got a business, make sure you've got an antenuptial contract in place so that you're not responsible for your partner's debt or the company's debt.
Yeah.
And
just before I let you go, Rihanna, just back to your question on customary law, and I think Sheila-Ann mentioned this earlier. For people to remember, we were discussing marital regimes and how it affects your finances. There are also other avenues to claim, like from a pension fund, and that's a separate issue. It's not to say now, if you are financially dependent of a person, you can't claim from the pension fund because of whatever marital regime. So that's why it's important to consult with a financial professional and look at the picture in total. So in terms of all these pillars of law, what are the implications? Because it does happen that, couples live together. The one couple is financially dependent on the other, and they live together for a long time, sometimes even have kids, and then only consider paying a lobola or whatever the case may be. The spouse in that case may be a financial dependent, or let me not use the word spouse, the partner in that case may be a financial dependent, meaning they can claim via other avenues, but they're not officially married, if that makes sense. So always important for people to consult the financial planning professional to make sure that all these different things and avenues are looked at and addressed and planned for carefully.
thank you, guys. And I think you have mentioned it a couple of times. Speak to a financial professional. You can find such person at www.fbi-mymoney123.co.za. Speak to a financial professional. They are there to assist with all your questions and to make sure that you plan correctly for your future. Thank you so much to my two speakers, Katlgeo and Sheila-Ann Roby. We really appreciate your time, and thank you to our audience and people listening. Please make the good financial decisions.